Came in from $750 to $40,000 over nothing. I'm fucking this whole state up then, man. He's switching me around. Why don't you stop switching me the fuck around, bro?
How about you stop talking and listen?
You used the F-bomb with me.
No, I didn't.
Officer, Sergeant, your name or Corporal? I can't tell.
Sergeant Mitchell.
James Schlock 30720.
These guys don't get it, do they? Why didn't he show? Why didn't you show up? Why didn't he show up?
And my mail goes to I'm in an apartment complex, and I don't get them. Sometimes I don't get them mail at all.
You remember getting stopped, right?
I'm sorry, what? I can't hear. I'm half deaf. I'm sorry. I'm half deaf.
All right, let me put it to you this way. You got stopped. I don't want you to say acknowledge that you did, but at some point it's going to be pretty clear to me that you did get stopped. If you had mail issues, you should have called the courthouse. You should have called the police department. Now you got yourself in a real predicament. What, is there a problem with something I just said? I don't want you to cop an attitude with me. If you do, we're going to have a bigger problem.
No, I'm half deaf. I can barely hear you. I'm half deaf. I can't hear you. That's the problem.
All right. Can you hear me any better now?
Yeah, that's all the problem was. I couldn't hear you before. Now what's going on?
Does he stand mute and waive formal reading?
Yes, Your Honor.
I'm entering a not guilty plea. I got an operating with the presence of drugs, and I got a resist, hinder, and obstruct an officer charge. So your lawyer is telling me you...
What started as a routine bond hearing is quickly turning into a courtroom credibility battle. The judge isn't focused only on the underlying charges anymore. He wants answers about why the defendant repeatedly failed to appear in court. Missing a court date can create serious legal consequences, especially when notices were sent multiple times. The tension is already building because the judge sees responsibility while the defendant sees miscommunication. Who do you think the evidence supports so far?
Stand mute and waive formal reading. Has he been printed on this, Sergeant?
Yes, he has.
I want to know why he hasn't shown up.
I apologize.
Why did you not show up?
I didn't get notice.
Well, you knew you got stopped. You should have called the court. We sent it to... Is that your address?
That's my address, but sometimes things get dropped. Sometimes things get dropped. You know what I mean?
We sent 2 letters there. If they came back, we would have put them in the file.
Oh,
you were supposed to be here on April 30, and then you were supposed to be here on May the 14th, and you didn't show up either time, and I don't have any return envelope or any envelope stamped that was sent back to the courthouse, or it would be in the file. Where does he work?
He's on disability. But he has no prior cases. He did tell me about his mail issues. And
he's got prior cases. I mean, he's got a heck of a history here. Pullman.
This is where the hearing takes a dramatic turn. The defendant begins challenging the court's discussion of his criminal history, repeatedly interrupting while the judge is trying to explain its relevance. Legally, older cases may not determine guilt, but they can still provide context during bond decisions. Notice how the atmosphere shifts from clarification to confrontation. Every interruption is making the judge less patient, and that's rarely a winning strategy inside a courtroom.
Evasion 98. Impaired 99.
You can't hold that against me. You can't hold that against me. You can't hold none of that against me because that was over 12 years ago. You can't hold none of that against me. 10 years or older, they don't hold it against you.
Sure, it is your history. I will tell the court that it is pretty old, and you make the right conclusions based on that.
Okay? I'm getting mixed signals. I'm getting mixed signals. Yeah, you're going to talk about my history. Just 10 years or older.
Really? Thank you.
I could just go to some trial with it and then show you that they kept me in the police station for 2 days before they took me to the hospital to even prove that I had drugs in my system.
Talk about the substance,
And
especially.
they kept me for 50.
The consequences arrive fast. After a series of interruptions, profanity, and defiant remarks, the bond jumps from hundreds of dollars to $40,000 with a 10% requirement. This isn't punishment for the charges themselves. It's the judge responding to behavior displayed in court and concerns about compliance. The defendant appears shocked by how quickly things escalated. Was this an overreaction, or did he create this outcome through his own conduct? Let us know below.
15 days in the hospital. And then, now you ain't doing this. Just let me go. I'll come to court and I'll take care of it. I promise.
Sir,
I just
you'll
didn't
have
get
an
notice.
attorney next time who will discuss those issues with you. Today, we're just concentrating on bond.
I was reading your history as I was reading it
Yeah,
to
well,
myself.
you can't read my history because it's over 10 years
Yeah.
old.
Don't interrupt.
Are you dealing with me or
got a
dealing with
horrible
them?
hip. You
He's
got
switching
a-
me around. Why don't you stop switching me the fuck around, bro?
How about you stop talking and listen?
I'm going
I
to
can't
set
if
you
I'm deaf.
down now. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. If you're going to be so defiant, that tells me you're a flight risk. 40,000, 10%. No alcohol, no marijuana, no illegal controlled substances. None.
My bond is 40,000.
10%. It could be 40,000
Can't be because
if you use
it
the
can't be
F-bomb
because
again.
I have 2 misdemeanor charges, bud.
Sit back.
We're going to trial then, bro.
Sit back.
It came in from $750 to 40,000 over nothing. I'm fucking this whole state up then, man.
You got
We're going
about
all the way to
15
Supreme Court. We're going to court on this.
You got
Now we're witnessing a complete reversal. Moments after arguing, threatening lawsuits, and insisting he wanted a lower bond, the defendant is apologizing and asking to start over. But judges often pay close attention to a person's first reactions under pressure. Once a courtroom loses confidence in someone's credibility or respect for the process, rebuilding that trust becomes extremely difficult. If you were the judge, would the apology change your mind at this stage?
about
You can't
15
sit there and then take me from a $250 bond to 40,000 for nothing.
You just used the F-bomb. You're disrespectful. I think you're a
No,
flight
I'm not.
risk. You got 15
I'm
criminal
not. How am I a
convictions
flight
on
risk?
you. Listen,
I live right here. I don't even have a car.
Stop interrupting.
I can't hear
40,000.
for one.
well, you seem to be able to hear when you started to defend yourself. 40,000, 10%. You cannot leave the state, cannot violate a law.
So you keep me in
must
jail the whole
appear-
time?
Listen, if you give me one more bit of guff, I'm setting this case for next October, and I'm setting a bond of 100,000 cash. You want to keep going on, tough guy?
This hearing ultimately became a lesson in courtroom behavior as much as a legal proceeding. The judge concluded that the defendant's repeated interruptions, aggressive attitude, and refusal to listen justified stricter bond conditions and a firm response from the bench. Whether viewers agree or disagree with the bond increase, the ruling highlights how conduct inside the courtroom can dramatically influence outcomes. If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
You want
I'm
to
not
keep
being
going
tough. I
on,
can't-
tough guy? Feel free.
I want a
Yeah.
PR bond. I want to go home. I want to go home. I want a PR bond.
40,000. No,
Please.
no, no. You're
Well, then
disrespectful.
I'm suing you then.
Good, sue me. Okay? Come on, bring it on. Can't wait.
I'm never going to get out, man.
40,000.
Come on, man. Don't do me like this.
Will the court
What?
give us this possible?
Yeah, I'll do that, but he's not going to yell at me and call. Use
I didn't
the
mean to yell at you.
F-bombs.
I can't. I'm deaf. I didn't mean to yell at you.
You use the
I
F-bomb.
apologize. Can we start over?
No,
Please?
no,
Can we start over?
no,
Please?
no, no.
Please, can we start? I can't hear you. That's why I'm yelling. I'm not
You
a tough
use-
guy. I just.
You use the F-bomb with me.
No, I didn't.
Oh, you did?
I never cussed you. I would not disrespect you. I just. I can't. I
Listen.
wouldn't disrespect you like that. I apologize.
Listen,
Please, my mom's dying right now. Will you please let me go home?
I'm convinced you can hear a lot better than you think, or at least letting on, because all of a sudden, you were able to comprehend. Now, I'm not going to argue with you. I'm telling you, it's June 11th at 9:30. 40,000, 10%. One more word and I'm setting it for June 25th.
This is a different charge. Why are you doing two different charges? That's not me.
There-
What you read
It's
right now
gonna
is
be
that's not me.
next
June
week.
11th. That's not.
We're gonna get you in front
It's
of
two
the
different
court,
people.
and the court could review your bond at that time. And you can discuss the issues with your attorney at that time.
Oh, you're my attorney. So I don't know how it's going on
I
here.
said,
I get 5 different things going on right now. That's all.
June 11th is your next court
Thank you,
date,
sir.
is what they're saying.
One thing I've decided, Mr. Williamson, I'm not listening to tough guys. You got it? You want to play tough guy? Get into
I'm not playing
WWF
tough
or
guy.
something. I don't know what to tell you. June 11th.
I'm sorry. I apologize.
No, it's not good enough.
I'm half deaf. I didn't know all the screens were up.
I could set it, I could just find you in contempt of court.
I didn't know that all the
For 30
screens were up.
days. One more word, I'm gonna do that. I'm telling you.
I have mental disabilities. Just hold on.
Days.
I have mental disabilities.
Cut
Can
them
you give me
off.
1 second?
Cut him off, Lisa, please. Wilkins Alexander III. 267, 665, 269, A and B.
Good morning again, Judge. It's, John Grazie.